Welcome to recent developments in California property tax law. I'm Philip Aaron, chair of the Beverly Hills Bar Association's tax section. The tax section is sponsored by Hochman Salk and Tosha Perez. The Hochman Salk and Tosha Perez BC advantage is experience, an eye for innovation, and genuine dedication to client, their family, and their business. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state court, the firm is also active in white-collar defense and commercial disputes. I'm delighted to introduce today's speaker, Greg Broege. Originally from the Jersey Shore, Greg began his legal career at Latham Watkins and has exclusively on California state and local tax since joining what is now Ayelet, Polay, Ayub, Matarisi, and Broege in 2009, where he became a partner in 2016. Recognized as a super lawyer and an early rising star by the California State Board of Equalization, Greg has also received the Member Achievement Award from the Institution of Professionals in Taxation. He has held leadership roles in the LA County Bar Association and the Institution for Professionals in Taxation, and regularly speaks at events for bar associations, tax institutes, and CPA societies. He also teaches continuing education in state and local tax at Cal State LA and has been published widely in respected tax and legal practitioners. Greg, take it away.
Hi, everyone. I obviously can't hear you or see you, but there is a Q&A function. If you have a question during the presentation, feel free to put it in there. I'll try to monitor it. If not, I'll get to it at the end. But sometimes it's good to answer it while we're on the specific topic. Before I get into the kind of case law update that we're going to go through during the presentation, I always like to start every property tax presentation with one of the most important things, which is what are the appeals deadlines and how do you contest an issue that you might have with either your property taxes or your client's property taxes. Excuse me. So there's a couple different appeals periods and they can be quite confusing. And they're also extremely important because in property tax, we have a system that's set up with a quasi-judicial administrative agency called the Assessment Appeals Board, which is separate and apart from the county assessor who actually assesses properties and values them. The Assessment Appeals Board is the governmental agency that's set up to handle property tax disputes. And in almost every situation, other than exemptions and maybe other very limited circumstances, you have to go to the Assessment Appeals Board first. And if you do not, go there, you have not exhausted your remedies, and you could win your case but not get a refund, which is generally a fairly big deal. So there's a couple of different periods. The first is the general regular filing period. We're in the regular filing period for every single county in the state of California right now. The filing period runs from July 2nd to either September 15th or November 30th, depending on what county you're in. If the county gives an assessment notice, you're on September 15th. San Francisco, Alameda, Ventura, those are examples of counties where you have to file your regular appeal by September 15th. Most of the state and most of Southern California, other than Ventura County, are all just November 30th counties. This year, November 30th is a Sunday, so you have until December 1st to file your appeals. A regular roll appeal is an appeal that challenges the assessment as of the lien date for that tax year. So the tax years are run on a fiscal year basis. They run from July to June. So right now we're in the 2025 tax year. It just started at the beginning of last month, and it will run through June 30th of 2026. A regular roll appeal will challenge the assessment as of the lien date, which is January 1 of each year. So the January 1, 2025 date is the lien date for the 2025 tax year, which runs July 1 to June 30th. That is generally used for Prop 8 decline in values, which is, hey, I think my property is worth less than what my trended base year value is. Or if you missed filing an appeal on either a supplemental or escape assessment, you can sometimes correct the issue, generally only on a prospective basis by filing a regular roll appeal. So there also are appeals periods that are outside the general regular filing period. And those are if you get a supplemental assessment. Now, a supplemental assessment is issued on real property if you have a change of ownership or completion of new construction. They will value the property as of that date. So if you purchased the property October 10th, 2024, you will get a 2024 supplemental assessment, which reassesses the property to the fair market value of it as of October 10th, 2024. Now, it's clear it's the fair market value. So, if the value's gone up from your prior roll value, you get a tax bill. If it's gone down, you'll get a tax refund. The appeals period for filing appeals on supplementals are either 60 days from the date of mailing of the notice of supplemental assessment, or in certain counties, and Los Angeles is one of those counties, 60 days from the date of mailing of the bill. So you have to be careful what county you're in. Most counties throughout the state are notice counties. However, sometimes it's confusing because like San Diego, they combine the notice and the bill into one document. LA is a bill county, Marin County is a bill county. So you got to make sure you're appealing the notice/bill within 60 days of whatever is the operable document that leads to the appeal. Similarly, with escape assessments, that's when property escaped assessment as of a lien date. Those are also issued outside the regular period, and those also have a 60-day period. Again, either from the notice or the bill, depending on what county you're in. And I should mention in LA County, if the value goes down, then you're only going to get a notice. You're not going to get a bill. So then the 60 days runs from the notice if the value goes down. With escape assessments, there's an even kind of more confusing little question, which is they issue what's called a notice of proposed escape assessment. That comes before the notice of enrollment escape assessment. If you file on that, your appeal is premature and invalid and void under the law. So you really, really got to make sense. One, you don't sit on things. I just had somebody today email me bills from May 20th, 2025. They're outside of the period. There's nothing we can do to get at those bills. So you got to act quickly, and you got to make sure you are appealing the same thing. Someone just asked, a married couple own a house with their son, all as joint tenants. If the married couple transfer their share of the house into a revocable living trust, would it lead to reassessment of the property? Great question. Not a part of the presentation, but I'm happy to answer it. And the answer is not enough facts right now. If the married couple and the son bought the property all as joint tenants, then the transfer from the married couple of their interest to their trust would not be reassessable. However, if the married couple bought the property originally and then added the son as a joint tenant at a later time, or vice versa, the son bought the property originally and then added the married couple at a later time, then the transfer of the married couple's interest to their trust would sever that joint tenancy and cause either a 1/3 reassessment or a 2/3 reassessment, depending on what the percentages are. So whenever anything's owned in joint tenancy, you got to know how it got into that joint tenancy, because there's very complex change of ownership rules dealing with original transfers and non-original transfers. And you just can't look at it as like, well, they owned it, now they own it in their trust. That's no problem. Well, it's generally not an issue. It's never an issue with tenants in common. It can be an issue with joint tenants. I see estate planners make that mistake a lot because it's a very kind of arcane little rule. So just be very, very careful. You got to fully analyze the issue. With that, I'm going to go into the presentation. So there has not been a ton of new case law in the property tax area or a ton of changes within the last year or so. There were some major changes like 4 years ago when they got rid of the parent-child exclusion and they changed the over 55 base year exclusion. And the one major case that's outstanding, I was kind of crossing my fingers that it came out before this presentation on intangibles, is that the California Supreme Court has been fully briefed, has had oral argument, but the California Supreme Court has yet to issue a decision. So we can chat about that case a little bit, but obviously what the Supreme Court says is going to be the thing that matters a lot. So some of these cases are unpublished. Obviously, if it's an unpublished case, it is not citable and not precedential. However, they are helpful. They in certain ways. One, they cite other cases throughout them, so you can find other citations, and two, you understand how the courts might feel about a certain issue. And because of that, I think they can still shed light on a lot of things. So the first case kind of deals with how important the administrative process is in property tax. As I mentioned, for locally assessed properties, everything goes to the Assessment Appeals Board first. For state assessed properties, and there's very specific things that go to the state assessment because they're taxed on a unitary basis because they're throughout the state, like electric companies and stuff like that. They're assessed by the State Board of Equalization, and they have to go to the State Board of Equalization for a hearing prior to going to court. Now, there's different review standards for state assessed properties. They're reviewed de novo in court, where for locally assessed, and this is very, very important. So we get a lot of calls on this. There's a limited standard of review for locally assessed properties. If you lose at the board on a factual issue, you've kind of lost the case completely, because there's only review on a substantial evidence standard, which means that the court does not get to reweigh the evidence. They just check if there's evidence in the record to support the decision. If there is, whether they agree with it or not, they uphold the decision. So the Assessment Appeals Board really acts as the trial court for locally assessed property tax cases. So this first case, the La Paloma case, is a state assessed property. It's a power plant. And they wanted refunds for 2012 through 2016 tax years. And they tried to do it a couple different ways. For 2012, they originally stipulated to a value at the State Board of Equalization, and then filed a suit for refund saying, hey, we actually want more. And you can understand why. These local quasi-judicial hearings, especially in certain counties and certain areas, can sometimes get the reputation a bit of a kangaroo court, or very biased towards the government. Not always, but they can get that reputation. And so I think Paloma here was trying to get to the court quicker to get a full kind of trial on the issues with hopefully a more impartial trier of fact. So they stipulated to a value before the board and then tried to go to court. And the court was like, no, you can't do that. You can't short circuit the process. You agreed to the value. So you don't have a dispute. You can't agree to something before the board and then dispute what you agreed to. And so you have not exhausted your administrative remedies. You're just not allowed to be here on this 2012 case. It's very important that you have a full hearing at the administrative level, or you can sometimes stipulate that it's a pure legal issue that the courts are better to decide, but you're not stipulating to a value. And here they stipulated to a value and then challenged that value that they agreed to at the administrative level in court. And the Court of Appeals said, no, you're out of luck. You're stuck with what you stipulated to before the California State Board of Equalization. So in the later years, 2013, 2014, and 2015 and 2016, they didn't have that same stipulation issue. However, in their petitions to challenge the assessments made by the State Board of Equalization, and in their refund claims, they were limited as to what they argued for. So let's just really simple kind of, fake math. This weren't the real numbers. Assume they thought the property, originally was worth 100,000, but then at trial they were able to prove that it was really only worth 50,000. The court said, well, you don't get the refund between the difference because you didn't properly exhaust your administrative remedies. You only asked for 100,000 at the administrative level. Just because at trial you proved you should get an even lower value, you can only get to what you asked for. And that's why it's very important when you file your petitions and your applications for changed assessment with the Assessment Appeals Board, whatever you think the value is, go lower, because something might come up. Now, you can always amend them at any time, but people sometimes forget to amend them, forget to do it. And a lot of times the application acts as the claim for refund. You need to make sure that you're not messing up at the administrative level. These simple forms, the 2-page form that doesn't seem that much, can cause major issues, because this taxpayer lost out on a lot of money here because of issues that were made at the administrative level. Also, one thing that's clear too is they don't want you to just present a bare bones appeal at the administrative level. You need to do a full fleshed out hearing. And at the state board, again, no one thought that was that as important because they had full de novo review at the trial court. The Assessment Appeals Board, that's where you really need to do it. You need to make sure that you are treating that like a superior court trial. It is not go there, throw whatever against the wall, see what sticks, and then, oh, we'll deal with it and clean it all up in trial. You have to take that Assessment Appeals Board hearing, witnesses, testimony, documents, evidence, et cetera, et cetera, et cetera. The next case, again, a state assessed case. But here, how it works with the state assessments is you get assessed at the state level. They then send the values down to the counties on a prorated basis, and the counties issue the bills. And with Prop 13, when Prop 13 was enacted in the 70s, it restricted the tax rate to 1% general levy of the value. It also imposed limitations on the value, plus voted indebtedness. And that's why, if you notice, if you live in the city of LA, you're like at 1.2% tax rate. If you live in Glendale or Burbank, you're closer to 1.1. If you're down in Orange County, you're barely above 1%. If you live in like City of Industry, you're at like 1.5 or 1.6%. Not that many people live there. It's kind of a family town. And those differences in the tax rate are the voted indebtedness that gets voted onto your tax bill, which is different than the direct assessments. The voted indebtedness are still based upon value. It's a percentage of value. Direct assessments are just pure, you're getting assessed $300 for the mosquito district or whatever. So as a part of the California Constitution, it says that utility companies should be taxed in the same manner, same extent and same manner, not utility companies, state assessed properties, excuse me, should be assessed as the same extent and manner as the locally assessed properties. And because of this very complex formula that they have for state assessments, where they kind of weight all of the voted indebtedness, the property was not always at the same 1% and change as the locally assessed property was. And while it doesn't seem like a difference, oh, well, the locally assessed property is at 1.1524%, and we're at 1.2044%. When you're getting assessed on billions of dollars of assessments like the state assessees, that number adds up significantly. And so they filed a suit and said, hey, you can't be we're same extent and same manner. You have to assess us exactly the same rates as the locally assessed property. Otherwise, you're violating the California Constitution. And this case had been, a similar case had been handled before by a different Court of Appeal district. And this district came to the exact same decision, which says, no, oops, sorry, there was one more slide. No, the issue is it's just an enacting legislation, but it doesn't have to be to the exact same rate. It's in the same manner, coming up with a fair market value and doing all that stuff, but it doesn't have to be to the exact same rate. The debt service doesn't have to be the exact same rate. It just has to be a reasonable method that they're using to account for all the different voted indebtedness in the county. And so the taxpayer ended up losing, even though you kind of look at the plain definition of it and you say same extent and same manner. That really sounds like it should be taxed at the same rate, but the courts, and if you'll notice, there's going to be a very consistent theme of the loser is generally the taxpayer in a lot of these cases. And that's because the courts, even though you think they're more unbiased, they are generally, you're the away team as the taxpayer, to put it in a sports sports analogy. The government's the home team, and the officials are looking to give the calls to the home team if they can. This is something that happens a lot because I shouldn't say happens a lot, but really surprises people when it happens, and happens more often than people would think. In this case, just a regular old house, a plaintiff purchased a property for $450,000. And I hear it all the time. Oh, Prop 13, you just get assessed at your purchase price. That is not necessarily true. Actually, it's not true at all. The law is you get reassessed at fair market value. Now, if you have a transaction that is an open market transaction between a willing buyer and willing seller, and there's no contingencies on either of them, then the purchase price is presumed to be the fair market value of the property as of that purchase date. And in most instances, you go and buy a home in Encino and it was on the MLS, and you're the winning bid, and they're just going to enroll the purchase price 99 times out of 100. But they don't have to do that, they being the county assessor. If they think that you bought something below market, they can put on a higher number. If they think you bought something at an above market value, they can legally put on a lower number. However, I have never seen them think someone bought something at a higher than market value. I've seen the opposite. I've never seen them go, boy, you really paid too much, we're going to put something less on. So in this case, the buyer bought a house for $450,000, and the county came back and said $970,000. Now that's pretty tough on the buyer, right? Because the buyer is probably projecting taxes of, okay, I'm going to pay taxes about $5,000 a year based upon that purchase price. Oh my God, now I'm going to be over $10,000 a year because the county thinks they know better than what a property sold for. Now the plaintiff then came and submitted photographs to the house to the assessor, and the assessor came to the hearing and said, okay, we agree we were way too overzealous at $970,000, but we still think it's more than $450,000. We think it's $675,000. So they went, and that's what they recommended at the hearing. And they presented comparable sales to support that valuation. Because remember, for property tax valuation purposes, there's only 3 valid methods: the income approach, the comparable sales approach, and the cost approach. Those are the only 3 ways you can value a property. Now, for single family residences, it's almost always going to be valued on a comparable sales approach. Maybe some new construction will be the cost approach. And so they presented comparable sales. Now, the plaintiff showed up, and not understanding, one, the law, and not understanding the importance of the Assessment Appeals Board hearing, they didn't present any evidence, any comparable sales. All they did was they showed evidence of what bad state the property was in, but they didn't have any sales. They didn't have any adjustments to sales. They didn't do anything. They didn't have a valid valuation methodology. So even if the county board wanted to rule for the applicant, it would have been very difficult too, because they didn't present a valid valuation approach. So what's very important when you go to these hearings is you can't just critique what the assessor's doing. You have to present your own case in chief, to show that you're right, your value's right. Then you can critique the assessor. That's not a problem. But you can't just go there and only say what they did wrong. You need to show what you did right. Also, be aware that it's the purchase price presumption, as I said. It's overcome fairly easily legally. If either side puts in evidence of a different value, more than 5% difference, then the purchase price presumption immediately goes away. And so, once the assessor put in evidence of $675,000, there is no more purchase price presumption. And then the board just has to decide based upon the preponderance of the evidence. Who do they think is more right? I always joke that when the purchase price is against the taxpayer, that presumption becomes a lot harder. But when the purchase price presumption is against the assessor, the boards usually are a lot more willing to overlook what the purchase price is. And you just got to know kind of the situation that you're battling. So this one's a little older. This is from 2024, but it's an interesting case, and it has an interesting background. It's a change of ownership case where a corporation owned property and transferred it out to the owners of the voting stock of the corporation proportionally. But the assessor said, well, no, we don't think that should be excluded from reassessment under the proportional transfer exclusion, which is if you have an entity and it transfers the property to its owners in exact same ownership percentages, it doesn't get reassessed because this corporation had non-voting stock as well. And the question became, hey, when you're measuring ownership interests of an entity, how is it measured? Well, for partnerships and LLCs, the law is really clear. It's capital and profits interests. But for corporations, the law wasn't super clear. For Section 62A2, it's just said the word stock. It says it's measured by the company's stock. Now, in Section 64, a section a little longer about transfers of ownership interests, of legal entities, it clearly says the word voting stock. And so that was the debate, whether it's all stock or voting stock. And I got a question about the Kim case. I'll go back to that in a second once I finish the Prang case, then I'll answer the question. The question before the court was, hey, we know it's voting stock when you're transferring interest in entities, but when you're transferring the property out of the entity, how do we measure ownership? And for years, just in practice, everyone just used voting stock. That was just kind of the practice. It was kind of mentioned in assessors' handbooks here or there, never super clear, but that was the practice. But the County of Los Angeles took the different approach. They went to the Court of Appeal, fully briefed oral argument. The Court of Appeal couldn't decide, and they sent out emails to me, a lawyer up in Northern California, and the California State Board of Equalization, and said, hey, this is a confusing case. We understand that you guys do a lot of this work. Would you mind writing an amicus brief and telling us what your thoughts were? One, I almost deleted the email because it looked like junk to me until I was like kind of read it. I'm like, wait, what's going on? I'd never heard of this before. Two, I wasn't super happy that the Court of Appeal asked me to do work for free. But when the Court of Appeal asks you to do something, you kind of do it. And so independently, all three of us kind of wrote an answer, and I really tried to write it because I actually was always very nervous about that issue. Like I was aware of that issue and always advised people, hey, this could come up, like it's not super clear. And I kind of wrote, I was like, look, there's competing statutory interpretations, right? Like canons of statutory interpretation. One is, hey, if you say it one place, you said voting stock in Section 64, and you don't say it in another place, Section 62, well, then you meant to not say it. And so it must be all stock and not voting stock. But there's other ones that says that you really should treat everything in the similar part of a code and a similar part of the law the same. And that's from the Thrifty case and some from other cases. And there it's like, well, if you're using voting stock for the legal entity change of ownership, you should also use it for Section 62A2. And oh, by the way, here's why. If you don't do it, you kind of open up this big loophole that will allow people to plan around changes of ownership. Interestingly, I said that. And so I said, at the end of the day, I think the best answer is voting stock should be treated for both because of that. I said that. The State Board of Equalization said the exact same thing. The government agency tasked with coming up with the rules, and the Northern California attorney said the same thing. And the Court of Appeal said, thanks very much. Great job, guys. We disagree with all of you, and we're going to say it's all stock. And then it went up to the California Supreme Court. They took the case, and they came down the exact same way. It's all stock, which is interesting because now you can do some stuff. If I own 20% of a property and my business partner owns 80% and I want to buy him out, that's usually fairly difficult, right? If I buy the 80%, I get 80% reassessed. If we put it into an LLC or a partnership and I pay 80%, I get 100% reassessed. But if we put it into a corporation that I own 20 shares and the business partners own 80 shares, but his 80 shares are non-voting and my 80 shares are voting, that's a proportional transfer, no reassessment. And then I can buy out the 80 shares and there's no change of ownership because no one got over 50% of the voting stock. I already had over 50% of the voting stock. And that was the example that the Prang case even kind of mentioned in the decision. So I always say that planning technique is blessed by the California Supreme Court. They knew it was an issue, and they still decided the case that way anyway. So it's an interesting defeat for the taxpayer, but it opened up some opportunities for taxpayers as a whole. So I got a question. I'm going to click back to the Kim case. It says, so in the Kim case regarding comparables, is it really a burden shifting thing for the owner to defeat the presumption of liability of the home team's evidence? I'm not totally sure what that means, but the problem is once the assessor, because in single family residences, the burden is actually on the assessor, not the taxpayer like it is in other cases. And if the assessor goes against the purchase price that qualifies for the purchase price presumption, it goes on them. But once they put in the evidence, the burden's gone now, out, doesn't exist anymore. Now it's just whose evidence is better. And in the Kim case, he didn't even put in any evidence. So the assessor did have the burden there. They put in their evidence. Now there is no more burden. Now it's preponderance of the evidence. Who's got the better case? And the applicant didn't present anything. And so by definition, you're going to have to go with the assessor in that case. So the next case is another change of ownership case. And oh, by the way, just on the prank case, just FYI, it's just really hard to win legal entity changes of ownership in court. Any case using a legal entity, especially if it's transfers of entity interest, which this really wasn't. This was section 62A2. But just historically, the courts just don't seem to like them and just seem to find any possible way to say there's a change of ownership. In fact, since Prop 13 was enacted, there's only been one case where the taxpayer has won a legal entity change of ownership case. And that was the Michael Dell case, the Ocean Avenue versus County of Los Angeles case from 2014. That's the only time a taxpayer has actually ever won one of those cases. In every other instance, the courts seem to bend over backwards to try to get the assessor to lose. So just, if you're going to do some legal entity planning, you're doing change of ownership planning, you got to do it right. Because if you don't do it right, it's hard to fix it on appeal. It's hard to convince a court you didn't do it right. So just be careful with that. Someone says, on your example and for Prang, wouldn't the purchase of the 80% non-voting stock trigger the original co-owner rule and cause full reassessment? No. And here's why. Because, as I discussed in the beginning, the original co-owner rule and the majority ownership rule found in section 64C1 and section 64D measure ownership interests specifically by voting stock. So the non-voting stock does not count towards those tests. Because those rules are specific, voting stock, a transfer of non-voting stock, does not count towards a section 64 change of ownership. That's the thing we pointed out to the California Supreme Court by having two different definitions of what ownership of a corporation is. All stock for section 62A purposes, voting stock for section 64 purposes. You allow this kind of nuance to go. So no, it would not cause an original co-owner, which is a section 64D change of ownership. So the next case is Equinix LLC versus County of Los Angeles. And this was an extension of the Diana Lynn case that came out 10 years prior to this. So when you have an over 35-year lease, you create a lease of 35 years or more, that's generally a reassessable event, right? So let's say we created a 50-year lease, right? And 20 years later, it's now 30 years left. If you extend that lease another 20 years and you go back up to 50 years remaining, as long as it's the same tenant, that's not a change of ownership. Now, that was not always the position of the State Board of Equalization. They changed their position, and the Diana Lynn court confirmed that over, under, over is not a change of ownership as long as it's the same taxpayer. Now, what Diana Lynn also confirmed that wasn't in the rule is they said, hey, if you had a 50-year lease, and through the passage of time, now you just have 30 years left. If you buy the underlying fee interest, there's no change of ownership because you haven't met the entire definition of Section 60, transfer of present interest, beneficial use thereof, and substantially equivalent to the fee. And that's a playoff of when a lease does have 35 years or more, it's clear right in the law that if you transfer the underlying fee interest, there's no change of ownership. If you transfer the lease, there is, and vice versa. Once the lease drops under 35 years, it was, if you transfer the fee interest, change of ownership, transfer of lease interest, no change of ownership. What Diane said is, hey, if it's the same taxpayer that had the over 35-year lease, but it's now below 35 years remaining, and by the way, that in term includes written renewal options, then the transfer of the underlying fee interest to that lessee is not reassessable. And they said the rule on that's invalid, it's not a reassessment. So what these taxpayers tried to do is they tried to take that kind of analysis and said, well, we're not the lessee buying the underlying fee interest. We're a third party buying the underlying fee interest, but the person that is there is a lessee that used to have a 35-year or more lease, and it's just dropped below time. It's the same lessee. So if it wasn't a change of ownership if they bought the fee interest, it shouldn't be a change of ownership if we buy the fee interest. It was trying to extend the reason of Diane even further outside of the facts of Diane. Unfortunately for them, the court said, hey, there's a rule directly on point. We don't think this is the same as when it's the fee owner buying it, because we think at that point, everything is changing. The three elements of the Section 60 test, transfer of present interest, beneficial use thereof, and substantially equivalent to the fee. And so because of that, because all three are still transferring, we think there still is a change of ownership. Sorry, you lose, taxpayer. And that was a published decision. Almost immediately thereafter, an identical case basically happened, almost identical, happened down in the county of San Diego. So San Diego had almost the identical issue, and they held the exact same way as the county of Los Angeles, that it is a change of ownership. I'm kind of glad this case came out. Not, I didn't really care one way or the other. I didn't handle these, so I didn't really care one or the other how it was decided. But that kind of extension of the Diane case was kind of always out there. You'd have to raise it when you're planning things. And now that it's settled, you can just kind of drop it. If there's a transfer of the underlying fee interest when there's less than 35 years remaining on the lease, unless it's to the lessee who had a term of over 35 years, it's a change of ownership. It makes things a lot simpler on a going forward basis. So here's one where, we finally get some, kind of fairness for the taxpayer. And this is something that happens a lot, actually, especially with like parent-child type of stuff, right? Property's owned in a trust, parents die, the kids just leave it in the trust, they eventually just sell the property, they don't realize, they're like, oh, the trust always owned it, nothing happened, no change of ownership. They don't realize that for property tax, when the second of the parents to die died, it was a transfer, even though there wasn't a real world transfer. And then the county eventually figures out, oh, well, that trust sold it, but that's not the trustors. Oh, they died. Oh, there should have been a reassessment. And what do? They reassess, and they send all the notices and bills to the address of the property. Well, the property was sold, right? So the person, and they go on the unsecured roll, so it's not secured against the real estate, because they can't secure it against to a third party bona fide purchaser for value. And so, the new owner gets it and goes, well, that's not me, and whatever, and just throws it in the garbage, right? And by the time it gets back to the people who sold the property, well, they've missed all their appeals deadlines. They may have even missed their parent-child filing deadline, because the parent-child you have to file within 3 years of the transfer date or before transfer to a third party, except there's a savings clause that says you can file within 6 months of a notice of supplemental or escape assessment. Those notices that I was talking about at the beginning of the presentation in terms of appealability, they also are important for filing the parent-child. Well, here, that's kind of what happened. They did not file for the parent-child because it just remained in the trust, and they sold the property. And eventually the Orange County assessor realized it and said, okay, well, we're going to reassess. And they sent the escape notices to the address of the escrow company that handled the transfer to the third party. Where escrow doesn't know, they're like, what's this? Again, they just kind of got rid of it. Eventually, it got back to the beneficiaries of the trust, and they found out, oh, shoot, the tax collector's trying to collect taxes. They're like, what are these? And the tax collectors, well, we billed you for this. We sent you these notices. We never got anything. And had we gotten it, we could have filed a parent-child claim within 6 months, and there would be no taxes. It would all go away. Well, the assessor denied the application, And the AB and the trial court also denied everything because they said, well, it's not the county's fault. They sent it to an address, and just because you didn't get it, that's your problem, not their problem. And the Court of Appeal, I think, used a little bit of logic. They're like, no, wait a second. The law says like last address known to the assessor. Um, 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 you knew where these bills were going ahead of time. They could, especially in this case, it was going to a different address. It wasn't going to the property address. So they were getting all their bills at a different address. So like you were sending these bills for years to this address, and then you decide to send these escape bills to the escrow company. That's outrageous. You know, we're gonna use the date of notice as when you first contacted them and they found out about it, and because of that, you now have a valid parent-child, and this can all go away. So your assessments were invalid because you sent them to the wrong address. This happens a lot, you know, and so you got to be careful there. If you ever do get it, sometimes it's worth filing an appeal, even if you know you're outside of the appeals period, and arguing like, hey, it was impossible for us to do this because you didn't send this to the right address. And because you didn't send this to the right address, you know, the law never requires impossibilities. It's in the California Civil Code. And it's been written into the property tax law by the California Supreme Court in Williams and Fickett. It's impossible to file on something when you've never gotten notice from it. And when they send it to a wrong address, they shouldn't get away with it. And so just be careful on that. Before I move on to another one, I got a question, and by the way, I like the change of ownership questions. So if you have any change of ownership questions, the more the merrier. This is a question about a trust. Instead of gifting properties directly to children equally, instead, can you preserve Proposition 13? And by the way, there is no such thing as preserving Proposition 13. You're preserving your base year value. The whole system is Proposition 13. So you're preserving your base year value by gifting an option to purchase with condition of moving into the property. So the only child who would end up with the property to avoid reassessment. Non-owner children who don't live there won't ever receive an ownership interest in the property. Yeah, so what often happens is the trust will say there's 3 kids, and it'll just say, hey, the 3 kids get a third each of the interest. Now, if one kid wants the property, in order to get the full parent-child exclusion in that instance, you would have to equalize the distribution of the trust. So, you know, if there's 3 kids and the house is worth $900,000 with no loan, and there's 1.8 million of cash, easy, you know, 900,000 goes to the one kid and 900,000 of cash goes to the other 2 kids. But it never usually works out that easily that there's enough money to equalize. Usually the biggest asset is the home in a lot of people's trusts. In that instance, you can do a non-private distribution using a third-party loan taken out by the trustee of the trust that's secured to the real estate. Or if you ahead of a death, you can't do this after death, but ahead of a death, if you give a child the right of first refusal or the right of option to purchase, then you don't have to equalize the assessment. The child can just purchase the property directly from the trust. It will not be viewed as a sibling to sibling transfer, and they can qualify for the full parent-child exclusion, whether that's the old parent-child, if the transfer happened prior to February of 21, or the new parent-child under Prop 19. And then someone says, can one kid get a loan to pay it off? The kid cannot get a loan. An equalized distribution using a loan, here's the best example. House worth $1 million, no other assets. One kid wants it, one kid doesn't, 2 kids. The trustee of the trust would go get a loan. Usually you have to go to a hard money lender because most banks won't make those loans. They will secure the property with a $500,000 loan, right? $500,000 will be distributed to kid 1. The property subject to the loan will be distributed to kid 2. So they each got $500,000 of value. That old non-pro rata equalized distribution using a loan still works under the current new parent-child. Now, obviously, the new parent-child is limited in its benefits, but you can still do that if necessary. So here's the one that has everyone, who does property tax work waiting, especially if you have any hotel cases, because LA has kind of put all hotel cases on hold until they get the decision in Olympic in Georgia. There's three issues in Olympic in Georgia, but two of them, one deals with basically a kickback of transient occupancy tax from the city to Olympic in Georgia in order to incentivize them to build the hotels where they are. Another is a key money discount from the management company and whether that should be included in the cash flow. Those aren't as wide ranging of issues, and it'll be interesting to see where the Supreme Court comes down on those issues. Those were the two issues that were discussed in oral argument the most. Interestingly, the thing that wasn't really discussed in oral argument is the more wide-ranging issue, which is what is the proper way to value a hotel or any property that is kind of a business that's operating at the real estate, right? And one more Prop 19 question. Prior to Prop 19, in addition to the parent-child exemption, the estate also qualified for 1 million for other properties. Is that statewide or county by county? Statewide. So it's $1 million per parent of trended base year value, not fair market value, but trended base year value. But it is all statewide. So if you already transferred a bunch of property in San Diego County and you went over the threshold, you don't have another million in County of Los Angeles. So there's two major ways, and the hotel is the most obvious example. It's one major way is kind of called the Lenhoff method, and the other is the Rushmore method. The assessor for years has used the Rushmore method to value hotels, which they say, when you're valuing a hotel, when you're valuing a property, you're supposed to use the revenue that the property can generate, right? And the basic example is an office building, like what I'm in right now. We pay rent, and we're generally just paying rent for the real estate. There's very little intangibles or business value that we're paying for when we pay rent for our office space, right? But when you go to a hotel and you rent a room for $400 a night, you're not just paying for the room, right? You're paying for the concierge, you're paying for the different services that the hotel provides as if it's a resort. You're paying for the personal property. You're paying for the brand loyalty and the points that you're going to receive if you only stay at Marriott's or if you only stay at Hilton's, right? You're paying for the booking system that they're using. You're paying for a lot of different things than just the real estate. And so the assessor for years said, well, we use the Rushmore method, and all they do is deduct out the franchise fee and the management fee, just the expense. And that takes out all intangibles. Everything else is related to the real property and the personal property. And the taxpayers for years said, that makes no sense. Why would I pay Marriott $1 million a year to get $1 million of value? I'm not going to pay Marriott $1 million a year. I'm going to pay Marriott $1 million a year to get more than $1 million back. Like, I need to get a return of the $1 million and a return on the $1 million. And for years, the assessor stuck with the Rushmore, and for years, they won almost every single time. And then it wasn't until this case that came out, it's called Elk Hills, that came out, I think in 2013, maybe 2013, that range, where the Supreme Court dealt with the assessment of intangibles for the first time in years and laid down a test that basically said what the assessor was doing was wrong. Well, the assessor still said, we don't need to follow the Supreme Court because it's not specifically about hotels. It's about a power plant. And so even though it's clearly applicable to our valuations, we're not going to follow it. Then a case came down, Half Moon Bay, which was about a hotel. And Half Moon Bay specifically said the Rushmore method is an invalid method under California property tax law. And that's pretty clear, right? It's a published decision, binding on everybody. And a lot of counties, especially LA County and San Francisco County, said, well, it's not our county who fought that. So even though it is binding on us, we're not going to follow it. And then another case came down, St. Francis, and they said, yep, Rushmore's clearly invalid. You gotta, can't do it. And then LA finally got their time in the sun, and they have an Olympic in Georgia. And they said, well, we'll just try to get a competing Court of Appeal decision. And Olympic and Georgia, which, by the way, in an interesting move, the California Supreme Court granted review of the decision, but left the Court of Appeal decision as citable. Usually when they grant review, the Court of Appeal decision is not citable anymore until they issue a decision. It's still citable. And Olympic and Georgia very clearly said, hey, this is now like kind of settled. The Rushmore method is just invalid because you're not fully taking out the intangibles. You're just taking out the return of the intangible. You're not taking out the return on the intangible. Now, as I said, there's the two other issues that are kind of more specific to the taxpayer in Olympic and Georgia. It's at the California Supreme Court. It's fully briefed. Oral argument was in early June, I believe. The oral argument, the questions from the court focused almost entirely on the first two issues and very little on whether Rushmore is invalid or not. I expect the Supreme Court to confirm that the Rushmore method is invalid, which that's the last straw. Then the County of Los Angeles Assessor Office will finally have to come back and figure out something that is not the Rushmore method in terms of the valuation of intangibles for hotels and valuation of intangibles for any other kind of properties that are similar to that. A senior assisted living facility is another good example, right? You pay a certain amount per month to live there, but it's not like an apartment building. It's not just pure rent. You're paying for the help, you're paying for some meals, you're paying for all this other stuff. There's more than just real property. Even high-end apartment buildings, like some of these newer apartment buildings that have concierge services, and they'll go pick up your dry cleaning for you and everything, and it's all included in your rent. That's actually a lot of non-real estate payment that really should be deducted under the Elk Hills, Half Moon Bay, St. Francis, and potentially Olympic and Georgia um, um, case law. So this is going to be really important. There's also a huge backlog of hotel cases that are coming down that the assessor is going to have to deal with when this case comes out, and we should get a decision, fairly soon on that. So that'll change a lot and hopefully lead to a lot of refunds for taxpayers. So certainly something to kind of keep in mind on a going forward basis out there. And again, for all these type of cases, it's always very important, like, as you know, this case went to the Assessment Appeals Board, then it went to trial court, then it went to Court of Appeal. If they had not made these arguments at the Assessment Appeals Board, if they had not exhausted their administrative remedies at the Assessment Appeals Board, they would have had no chance of arguing this later at court. So it is, again, I can't stress enough how important it is on every type of question, change of ownership, value, or anything. You need to treat the Assessment Appeals Board case as a Superior Court trial, and request findings if you're worried about the decision. Because if you don't request findings, I've gotten a lot of people who had, property tax consultants or agents who aren't lawyers who are representing them at a property tax case, and they don't request findings, and then they lose, and they said, well, can we challenge it in court? And it's like, well, even if you had something to challenge in court, we don't know what to challenge in court because you didn't get any findings. So we don't know how the board decided. So there is all these very sticky little issues in property tax that can really turn you sideways if you don't get that. So that's kind of the update. I was very specific, so I have to get to 1:30, so I have 6 more minutes. If anyone else has a Q&A that they want to put into our question, that they want to put into the question and answer box, I'd be happy to help answer it there. And if not, I can fill the last couple minutes with, here we go. Who is required to apply for the parent-child exclusion for transfer of residence from a trust to a beneficiary upon distribution of all trust assets? The trustee or the intended beneficiary? So that's a good question. So actually the answer is both. So on the parent-child form, the transferor has to sign. And in a trust situation, obviously, if the parents have died, it's going to be whoever the trustee of the trust is. So the trustee of the trust is going to have to sign on behalf of the transferor, which are the deceased parents in a lot of instances, or if they're alive, the parents would sign. And then the second page is the transferee has to sign. Now there, If there's multiple children, only one has to sign the parent-child form. So trustee is for transferor, transferee child, only one of them has to sign it. Now, here's a great question. Prior to title being transferred and recorded, so do you do the deed? Do you do the parent-child before the transfer happens or after? Well, legally, you can do it the moment the person dies. So you can do it before, but you can also wait until after. And sometimes it's a little less confusing if you wait until after, so long as you're within all the relevant time periods, because then on the form, you can reference the deed transfer out of the trust. So they know that that deed transfer out of the trust relates back to that parent-child. Because I've actually had that happen where they were just taking forever. They filed a parent-child. It got approved as of the date of death. And then there was a deed transfer out of the trust to the kid, and the assessor reassessed that. And we had to go back, challenge it, and show them, hey, that's actually just the transfer to the beneficiary. That's not reassessable. They always agree, but it just added more time. So I think it's if it's okay on timing, it's sometimes better so you can reference that deed on the parent-child form, but you can't always do it. Sometimes you're coming up against deadlines and whatever. And the other thing you got to remember, because this is happening so much, and I hate that the state board put this into their rule, because I actually don't agree, and I don't think this is what the constitutional amendment for Prop 19 actually intended. But if you do not file for the homeowner's exemption within a year of date of death, regardless of if it's been deeded out or not, even if you timely file for the parent-child, you're only going to get prospective relief. You're not going to get full retroactive relief. So you have to get the homeowner's exemption on file within a year. And if you don't know who's going to live there, or if you're not sure, just file for everybody. It's just intended beneficiary, just file. Because you can always amend the homeowner's exemption later, but get something on file that you can point to within a year. It should be on your little list now. If someone comes and they said their parents passed away or something, you've got to file that within a year. I have another question, off topic sort of. Any updates on the ULA mansion property slits? 50-50 to sidestep the documentary transfer tax and LA City's efforts to combat the technique. Yeah, so some people have tried to get kind of smart, and right now the lower level threshold for ULA is like 5.3. Originally it was 5, but they trended up. So say you're selling a $10 million house today. Well, I'll sell you a 50% tenant in common interest for $5 million, a 50% tenant in common interest for the other $5 million. I'm under the thresholds, no ULA. The city set up a task force to capture those exact type of transactions, and they are, for the most part, catching them and assessing them. So I would not be trying to do that. I don't think that's the brightest planning technique. I think there might be some better ones. Obviously, there's no penalties or interest with ULA. So if you want to take a run at it and hope they don't discover it, I know some have definitely gotten through the cracks. If not, you'd have to file appeal and challenge it. And, I don't think you're going to win at the administrative level on that. Nothing's gotten to court on that yet. But, I think that's a ripe argument for like sham transaction, substance over form type of thing for the city. Someone said, what about ULA selling business building, but still applies? ULA only applies to the transfer of real estate. So it doesn't apply to a transfer of a business. It only applies to the transfer of real estate. I have another question. How does a step parent surviving a parent impact an eventual parent-child transfer? They're still, step parents are still considered parents. So you can still, a step parent, I'm not totally sure what the question is there. A step parent can still transfer to the child. There is a special rule though for the grandparent-grandchild that the step parent then is like kind of carved out as a non-parent. So it depends on what the question is. But there's very specific rules on step parents. If the property is never transferred from a trust after a parent's death, there is no reassessment. That's incorrect. So even if it stays in the trust, it is a reassessable event. Now, maybe the county doesn't catch it because they don't know about it, but that doesn't change that it was a reassessable event. We look through trust. When the trustors die, it is a reassessable event the moment they die, even if you don't ever take the property out of the trust for the next 30 years. The reassessment occurred. Now, again, there's a difference between what they might catch and not catch, but just because it remains in the trust does not mean it's not reassessable. Another question, can you please clarify when appeal can be filed for a decline in value that does not become apparent until after an arm's length sale at a price below assessed value after expiration of a tax year? Boy, I'm not sure what that means. So decline in value appeal has to be filed as of in the regular filing period. So it has to be filed between July 2nd and either September 15th and November 30th. The value is as of January 1 of 2025, and you are allowed to use any comparable sales that occurred before that date and up to 90 days after that date. So if you bought a property and then something sold just recently, say something sold June of 25, that's not relevant to a 2025 appeal. That sale would be relevant to a 2026 decline value appeal. I hope that answers the question. How far back can a county go for reassessment after a person dies and it never gets reported? So if it's a death, no, it's not reported timely, and there's no deed or anything like that, the answer is 8 years. They can always reassess, and they can go back 8 years of back taxes. So if it happened in 2002, they can reassess in 2002, but they can only issue 8 years of back taxes. And with that, I think we're for ULA, if you heard anything about the assessor accumulating multiple deeds from family members and entities, yes, not the assessor. The assessor has nothing to do with ULA. It's the city, and yes, they have been doing that. I think with that, we're actually over the thresholds, the time. Thanks so much, everybody, and thank you for all the questions. I really appreciate it.